Hey guys, this is Jen and I'm back. Last video for today, I promise. Oh, I always figured the question, Republic versus democracy. One nation under God, to the Republic for which it stands. So I've always thought of us as a republic. Well, as things go, I keep hearing people shouting out, this is a democracy and protect our democracy. I kept wondering, why aren't they saying republic? So I'm at thoughtcode.com or thoughtcode or period, whatever it is. Yeah, thoughtcode.com, all lowercase. And this is understanding types of government, republic versus democracy. What's the difference? Just what I wanted to know. Says, and this is by Robert Longley, and it's updated on May 2nd, 2024. And he writes, in both a republic and a democracy, citizens are empowered to participate in a representational political system. They elect people to represent and protect their interests in how the government functions. In a republic, an official set of public fundamental laws, like the U.S. Constitution and Bill of Rights, prohibits the government from limiting or taking away certain inalienable rights of the people, even if that government was freely chosen by a majority of the people. In a pure democracy, the voting majority has almost limitless power over the minority. So, the main difference between a democracy and a republic is the extent to which the people control the process of making laws under each form of government. So, in pure democracy, the power is held by the population as a whole. In the republic, the power is held by individual citizens. In democracy, pure democracy, making laws, a voting majority has almost unlimited power to make laws, and minorities have few protections from the will of the majority. In the republic, the people elect representatives to make laws according to the constraints of the Constitution. In the pure democracy, ruled by the majority, in the republic, the laws made by elected representatives of the people. And under pure democracy, the protection of rights. Rights can be overridden by the will of the majority. In the republic, a constitution protects the rights of all people from the will of the majority. And the early examples for the democracy is Athenian democracy in Greece, 500 BCE. And for the republic, early example is the Roman Republic, 509 BCE. So, is the U.S. democracy or a republic? The United States, like most modern nations, is neither a pure republic nor a pure democracy. Instead, it is a hybrid democratic republic. However, when the delegates of the United States Constitutional Convention debated the question in 1787, the exact meanings of the terms republic and democracy remained unsettled. At the time, There was no term for a representative form of government created, quote, by the people, rather than by a king. In addition, American colonists used the terms democracy and republic more or less interchangeably, as remains common today. In Britain, the absolute monarchy was giving way to a full-fledged parliamentary government. Had the Constitutional Convention been held 2 generations later, the framers of the U.S. Constitution, having been able to read the new Constitution of Britain, might have decided that the British system, with an expanded electoral system, might allow America to meet its full potential for democracy. Nevertheless, Founding Father James Madison may have best described the difference between a democracy and a republic. He says, quote, "It," which meaning the difference, "is that in a democracy the people meet and exercise the government in person. In a republic, they assemble and administer it by their representatives and agents. A democracy consequently must be confined to a small spot. A republic may be extended over a large region. Okay, the fact that the Founding Fathers intended for the United States to function as a representative democracy rather than a pure democracy is illustrated in a letter from Alexander Hamilton to Gouverneur Morris dated May 19, 1777. It says, "But a representative democracy, where the right of election is well secured and regulated, and the exercise of the legislative, executive, and judiciary authorities is vested in select persons, chosen really and not nominally by the people, will, in my opinion, be most likely to be happy, regular, and durable." The concept of a democracy, coming from the Greek words for people and rule, democracy means rule by the people. As such, a democracy requires that the people be allowed to take part in the government and its political processes. U.S. President Abraham Lincoln may have offered the best definition of democracy as being, quote, "a government of the people, by the people, for the people," in his Gettysburg Address on November 19, 1863. Typically through a constitution, democracies limit the powers of their top rulers, such as the President of the United States, set up a system of separation of powers and responsibilities between branches of the government, and protect the natural rights and civil liberties of the people. In a pure democracy, all citizens who are eligible to vote take an equal part in the process of making laws that govern them. In a pure or direct democracy, the citizens as a whole have the power to make all laws directly at the ballot box. Today, some U.S. states empower their citizens to make state laws through a form of direct democracy known as the ballot initiative. Put simply, in a pure democracy, the majority truly does rule and the minority has little or no power. Representative democracy. In a representative democracy, also called an indirect democracy, all eligible citizens are free and encouraged to elect officials to pass laws and formulate public policy representing the needs and viewpoints of the people. Today, representative democracies are very commonly utilized by nations including the United States, the United Kingdom, and France. Participatory democracy. In that democracy, eligible citizens vote directly on policy, while their elected representatives are responsible for implementing those policies. In this manner, the people determine the social and economic direction of the state and the operation of its political systems. While representative and participatory democracies share similar ideals and processes, participatory democracies tend to encourage a higher level of citizen participation than traditional representative democracies. So while there are currently no countries specifically classified as participatory democracies, most representative democracies employ citizen participation as a tool for social and political reform. In the United States, for example, so-called grassroots citizen participation, causes such as the women's suffrage campaign have led elected officials to enact laws implementing sweeping social, legal, and political policy changes. The concept of democracy can be traced back to around 500 BCE in Athens, Greece. Athenian democracy was a true direct democracy, or a mobocracy, under which the public voted on every law, with the majority having almost total control over rights and freedoms. Okay, the concept of republic is derived from the Latin phrase res publica, meaning the public thing. A republic is a form of government in which the social and political affairs of the country are considered a public matter, with representatives of the citizen body holding the power to rule. Because citizens govern the state through their representatives, republics may be differentiated from direct democracies. However, most modern representative democracies are republics. The term republic can also be attached to not only democratic countries, but also to oligarchies, aristocracies, and monarchies, in which the head of state is not determined by heredity. In a republic, the people elect representatives to make the laws and an executive to enforce those laws. While the majority still rules in the selection of representatives, an official charter lists and protects certain inalienable rights, thus protecting the minority from the arbitrary political whims of the majority. In this sense, republics like the United States function as representative democracies. In the U.S., senators and representatives are the elected lawmakers. The president is the elected executive, and the Constitution is the official charter. Perhaps as a natural outgrowth of Athenian democracy, the first documented representative democracy appeared around 509 BCE in the form of the Roman Republic. While the Roman Republic's constitution was mostly unwritten and enforced by custom, it outlined a system of checks and balances between the different branches of government. This concept of separate governmental powers remains a feature of almost all modern republics. Break, take a breath, a glass, sip of water. Okay. Republics and constitutions. As a republic's most unique feature, the Constitution enables it to protect the minority from the majority by interpreting and, if necessary, overturning laws made by the elected representatives of the people. In the United States, the Constitution assigns this function to the U.S. Supreme Court and the lower federal courts. For example, in the 1954 case of Brown versus Board of Education, the Supreme Court declared all state laws establishing separate racially segregated public schools for black and white students to be unconstitutional. In its 1967 Loving versus Virginia ruling, the Supreme Court overturned all remaining state laws banning interracial marriages and relationships. More recently, in the controversial Citizens United versus Federal Election Commission case, the Supreme Court ruled 5-4 that federal election laws prohibiting corporations from contributing to political campaigns violated the corporation's constitutional rights of free speech under the First Amendment. Further, the constitutionally granted power of the judicial branch to overturn laws made by the legislative branch illustrates the unique ability of a republic's rule of law to protect the minority from a pure democracy's rule of the masses. Still with me? Nah. Maybe so, maybe not. Oh. That's all on that subject. Accidentally tapped on something I didn't want to. History of ethics violations and expulsion in the U.S. Congress. They bring up examples of members of Congress in 2010 strayed beyond ethical boundaries. House Committee on Standards of Official Conduct charged a U.S. representative, a Democrat from New York, with 13 violations, including failing to pay taxes on rental income he received. Also in that year, the Office of Congressional Ethics charged U.S. Republican, representative, a Democrat from California, with allegedly using her office to provide assistance to a bank in which her husband owned stock to ask for federal government bailout money. There's 2 examples that were Democrats. I'm still reading. A reprimand is used by the House, and it's considered a lesser level of disapproval of the conduct of a member than that of a censure, and is thus a less severe rebuke by the institution. A resolution of reprimand, unlike a censure, is adopted by a vote of the House with a member standing in his place according to House rules. Suspensions involve a prohibition. What is wrong with me? Prohibition on a member of the House from voting on or working on legislative or representational matters for a particular time. But according to congressional records, the House has in recent years questioned its authority to disqualify or mandatorily suspend a member. Only 5 members have been expelled in the history of the House. The most recent being a U.S. representative of Ohio in July of 2002. After he was convicted of receiving favors, gifts, and money in return for performing official acts on behalf of the donors, as well as getting salary kickbacks from the staff. The only other House member to be expelled in modern history is a representative of Pennsylvania in October of 1980, following a bribery conviction for accepting money in return for his promise to use influence in immigration matters in the so-called Abscam sting operation run by the FBI. The remaining 3 members were expelled for disloyalty to the Union by taking up arms for the Confederacy against the United States in the Civil War. History of Senate expulsions. Since 1789, the Senate has expelled only 15 of its members, 14 of which had been charged with support of the Confederacy during the Civil War. The only other U.S. senator to be kicked out of the chamber was William Blount of Tennessee in 1797 for anti-Spanish conspiracy and treason. In several other cases, the Senate considered expulsion proceedings, but either found the member not guilty or failed to act before the member left office. In those cases, corruption was the primary cause of complaint, according to Senate records. For example, U.S. Senator of Oregon was charged with the Senate Ethics Committee with sexual misconduct and abuse of power in 1995. The Committee on Ethics recommended that he be expelled for abuse of his power as a senator by repeatedly committing sexual misconduct and by engaging in a deliberate plan to enhance his personal financial position by seeking favors from persons who had a particular interest in legislation or issues that he could influence. He resigned, however, before the Senate could expel him. In 1982, a U.S. Senator of New Jersey was charged by the Senate Ethics Committee with ethically repugnant conduct in the Abscam scandal, for which he was convicted of conspiracy, bribery, and conflict of interest. He too resigned before the Senate could act on his punishment. That's enough talking for me, guys. Thanks for watching. Subscribe, like, dislike, comment. I love it all. Everything is good. Everything is going to work out in our favor. Happy day. Bye-bye.